Can I keep my house if I file a bankruptcy? In California, probably yes. The most important part is at the end. Can't speak for other states. I'm only licensed in California. I'm not your attorney, so this is informational and educational information only. Might even be a little bit entertaining. We'll see. The Federal Bankruptcy Code says that you can keep a certain amount of property. It's limited though. There's not a lot that they let you hang on to. It's okay, I suppose, if you're in Michigan or someplace where home values are very low. But in general, that's going to be a challenge. So the Federal Bankruptcy Code turned around and said, okay, different states, you over here, you can change the values. You over there, you can change the values of whatever you want to. Most of the states decided to do that. California created two options. One big set of, you can keep all this stuff, and it works great if you have a lot of home equity to protect, and another list over here where if you don't have a lot of home equity to protect, you can choose that list of stuff to protect. The nice thing is, it kind of gives you something for everybody. If you don't have a lot of home equity to protect, there's a scheme where you can protect a minimum homestead of about $33,000. The $33,000 homestead can also be used as a wild card to protect anything that you want to. So now we're talking about RVs, boats, if you live on it, but it could also just be a coin collection because as a wild card, you can protect anything that you want to. So if you have a little tiny pot of gold and you've got 10 or 12, 15 coins in it, depending on the size, of course, you'd be able to protect it with that kind of a homestead. If you have a lot of home equity to protect, nope, that's not a wild card. But you can protect a very generous amount of home equity if you have home equity that you need to protect. So in California, you can protect a minimum of $300,000 under this second scheme of protecting things, a minimum of $300,000 of the equity in your home, up to the median equity of a home in your county. Now, there are limits to that because what they did originally was they said it's 300 to 600. If you're over the 600, you only get 6. Then they said the upper end 6 will be adjusted up incrementally year by year for inflation and changes in property values. Could probably also go down if home values in your county go down. So you have to pay attention to that too. Currently in Riverside County, California, it's about $615,000 that you can protect of the equity in your home. Now, equity in your home means the value of the home that you own. So this much is mortgage, this much is the value of the house. The difference between the two is your equity. So if the mortgage is $400,000 and the second mortgage is $100,000, so you have $500,000 in mortgages, and the house is worth $1 million, then there's $500,000 in equity over and above the $500,000 in mortgages. That extra $500,000 is your home equity. The home equity is what you can protect under this California law. But there are limits to that too, because the Federal Bankruptcy Code decided, hey, we're gonna limit you to a much smaller number if you bought the house within 1,215 days prior to filing the case. I like to think of the 1,215-day rule as the OJ rule. You know, after he was found not guilty of murder, a little bit later he got sued, and he was found to be a wrongful deather in under an hour. And when he decided that he would file a bankruptcy, he first moved to Florida, where at the time, the amount of equity that you could protect was 1.1 acres. 1.1 acres, no matter what the value was. So you buy the most expensive 1.1 acres that you can and move in. A little bit later, you file a bankruptcy. That was how it worked back then. Now, If you found to be a wrongful deather in your state and you move to another state to try and get a large home equity to protect in your bankruptcy, what's going to happen is you got to be there for 40 months, 3.5 years, and 1,215 days. You got to pay attention to that 1,215th day, because some months have 31 and one month has 28 days. So that can catch you. And that was the idea. They wanted to be able to trip people up who tried to go find a better place to file a bankruptcy in order to protect more home equity. Then they said, okay, also certain kinds of crimes, you don't get the big number either. So this brings us to the question of how long do you have to be in a state before you can use that state's protections for your property? It's 2 years, 730 days. If you haven't been in the state for 730 days, then they look at the 180-day period prior to that 730 days and see where you were. So, if you've been moving around a bit, you'll definitely need to talk to your attorney, talk to your bankruptcy lawyer about how long you've been where you've been and which bankruptcy protections can you use to protect your property. That's why I like to call it the OJ rule. I don't know if it was specifically because of OJ, but it sure looked like it. You have to have bought the house within 1,215 days. It's approximately 40 months, but you cannot go by months. If you count the months and you are not counting the days, you could very easily put yourself in a position where you're going to end up losing your house and end up with only about $200,000 in cash. If they do take your house when they sell it, they have to give you the amount that you can protect. Okay, there's still an exception to that rule, which is a positive thing in most cases, where if you purchased a previous house in the same state prior to the 1,215 days, then you sold that house and bought the house that you're currently residing in, then the 1,215 days counts from the beginning purchase of the previous house. But only if it's in the same state. Has to be in the same state. So you can keep your house in most cases. Summary: if you're talking about something very small, very cheap, very inexpensive in California, then you have this wild card value of around $33,000. That's great. You can also use that as a wild card to protect anything. If you're talking about something that you bought recently, your limit's going to be somewhere in the neighborhood of about $200,000. If you bought something before the 1,215-day limiting rule and then sold it and bought the next house that you currently reside in, you get the big number for the California protection, which is in Riverside County, it's about $615,000. Other counties a little higher. So it's just a matter of, you do have to double check that. You got to talk to an attorney in your neighborhood, in your area, who can advise you specifically about your case. And by the way, always talk to an attorney in your area, in your neighborhood, who can advise you specifically about your case. I'm not your attorney, and if you're not in California, I can't be your attorney. This is not legal advice. This is legal information, educational, perhaps entertaining, if you're lucky, probably not. And sometimes you have too much equity. Sometimes you better get an appraisal if you think it's close. This is the most important part. If you have too much equity in your home, they can sell your home. If you can protect $200,000 in equity and you have $600,000 in equity, they sell your house and give you a check for $200,000. If you have $615,000 that you can protect and you have $700,000 in equity, they sell your house and give you a check for $615,000. So this is the most important part. This is the thing that you have to remember. You can protect quite a bit in California, and sometimes you still have too much. Good luck, everybody.